but we will call this case. It is Maples versus the state of Michigan. It's a 15-minute mini oral argument on the application. That means each side has 15 minutes. As I understand it, Mr. Bendour and Ms. Renkel, you're going to be sharing your time. I'm going to leave you to manage that and manage any rebuttal that you want to try to reserve. And we can get started. I think, Mr. Bendour, you're starting, so you may proceed.
Thank you, May. Please the court, Mark Bendour on behalf of plaintiff appellant. I'd like to take 7 minutes and reserve 3 for rebuttal, leaving 5 for Ms. Frankel, if I may. As the court is aware, this case arises under the WICA statute, and the critical issue is the meaning of the phrase found in that statute. New evidence means new evidence that was any evidence that was not presented in the proceedings leading to the plaintiff's conviction. And in turn, the critical facet of that is the phrase not presented in the proceedings leading to plaintiff's conviction. What we have here is an unusual case in which at an entrapment hearing, Mr. Murphy, the person who was actually involved in the cocaine dealing, attested on several occasions, including while the case was pending against himself, that Mr. Maples had nothing to do with it. However, when it came time for Mr. Maples' trial, the plea deal with Mr. Murphy precluded him from testifying on behalf of Mr. Maples. So the evidence that was unavailable to Mr. Maples was the exonerating testimony of Mr. Murphy, but it had been given in an entrapment hearing rather than in the course of proceedings involving guilt or innocence. And it seems to me the big difference seems to be this. The adverse government position seems to be that as long as evidence was presented at any time in the proceedings, that's enough to render it not new evidence and therefore not usable and not allowing relief under WICA. The difficulty, I think, in a textualist sense, is that they are essentially putting a period at the end of the phrase not presented in the proceedings period and ignoring the limiting phrase leading to the plaintiff's conviction. And that's where we think that the textual error is, and that limiting phrase leading to plaintiff's conviction implies something that leads toward conviction, some part of the proceedings that involve guilt or innocence. And I guess one way to put it is if one were standing at State Street and I-94 and said, I want you to take the road leading to Detroit, you wouldn't go west because leading tends to imply in the direction of words to that effect. And part of the problem is if we look at the different competing definitions, there are several for leading. But we think in context, it certainly means proceedings that involve guilt or innocence. And the fact that there was an entrapment hearing, which has nothing to do with guilt or innocence under the D'Angelo case, doesn't disqualify Mr. Maples from recovery under the statute. The other facet of it, I think, is considering the implications. And in my brief, I mentioned the exclusion of alibi evidence. If one were to take the opposing approach, because it had been presented to the judge as an offer of alibi evidence, but then erroneously excluded, there would be no basis for relief once the appellate court said that you really can use that exculpatory alibi evidence. It seems at odds with what the statute means or is intended to accomplish to say that when you are erroneously excluded from alibi evidence, that evidence which was excluded was presented in the proceedings leading to conviction. And another...
Mr. Bendour, let me interrupt you, and just because with so little time, I want to make sure you have a chance to answer any questions anybody has. So let me go see who has questions. Justice Clement.
Thank you. I have two questions. So if we're looking at the statute and had the legislature meant that proceedings leading to the plaintiff's conviction means only trial or plea hearings, why did they use the language that they used rather than trial or plea hearings?
Well,
They had a choice in the language that they used, and
right.
so as you indicate, you think that they meant solely trial or plea hearings. Why didn't they just use that language?
Well, I don't know if it would be only trial or plea hearings, but certainly proceedings dealing with guilt or innocence. And I'm not sure exactly what all that might encompass in the criminal justice process. And unfortunately, we get issues like this when the legislature isn't as clear as it might have been and leads this sort of ambiguity.
Okay, and then my next question is, do you think that the approach introduces a possible inequity into the law where you have a defendant who had evidence wrongfully admitted against them, and they can't seek compensation, whereas defendants who had evidence wrongfully excluded are able to seek compensation?
That, I guess, is the legislature's choice when they don't provide relief to everybody who is exonerated on appeal and later prevails. It's only with this new evidence, and that's the legislative choice, I think, in saying, in essence, you're eligible for relief when you now have something available that you didn't have before. DNA, I think, is the common example. But that's a legislative choice, and it may be an anomaly, but it's what we deal with.
Thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
No questions.
Justice Zara.
Thank you. Mr. Bendura, I'm distracted by something in this case as I try to go through and consider the question of new evidence or not new evidence. I'm distracted by the question, I think, which is unanswered, whether this new evidence resulted in a vacation or reversal of the conviction here. That really wasn't addressed below, was it?
It was addressed by the circuit court or the Court of Claims. The Court of Appeals said, because we are going off on this other ground, we don't have to touch it. And therefore, I think the parties are probably in agreement that unless this court wants to take it on, the remedy, if we prevail, is to send it back to the Court of Appeals for resolution of that unanswered issue. But we have, I think, a pretty strong argument, because when you get down to the ultimate ineffective assistance and delay, what's a critical factor is prejudice to the defense. And had there not been prejudice to the defense, i.e. the inability to present Mr. Murphy's testimony, then we wouldn't have prevailed in the habeas proceedings.
Okay, thank you very much.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
Hey, counsel. Good morning. I just don't want you to feel bad about the technology. I'm using a cell phone because I can't use Zoom, and took me a couple of years to get off my flip phone. So I just want you to know I totally understand the challenges with technology. But having said that, I don't have any questions for you.
With that, I think I'll yield to Ms. Frankel.
Okay, Ms. Frankel, you may proceed.
Almost forgot to unmute. Robin Frankel appearing here on behalf of the state of Michigan, arguing on behalf of the plaintiff this morning with respect to this question. I don't intend to use a great deal of time, and I want to do my best not to set my timer, not to interfere with counsel's rebuttal time, but I do want to explain why we changed our mind. I've spent 2 years evaluating WICA claims, supervising lawyers, evaluating WICA claims, sitting on an executive board, reviewing recommendations and deciding whether to concede or contest WICA claims. And what I've learned over that time, and I think what we've all learned, is that this is an ever-changing landscape. WICA is still a relatively new statute. It is still developing. This court issued 2 opinions last year. You heard argument on Ricks last month, Maples today. And so what that does for us is it creates a situation where we need to be sure that we are always reviewing what we're doing. We want to make sure we're following the law and that we're applying it in a consistent manner. So what happened here is the Court of Appeals opinion came out and counsel filed his application for leave. And we took a step back and we looked at the pleadings, and we had 100 meetings, and we reviewed the statute and the language and did the research, and we decided we had been wrong. I think that the parties agree now, when you look at the definition out of Merriam-Webster, that the appropriate definition for leading to plaintiff's conviction is that a proceeding tends towards or results in the plaintiff's conviction. That requires a pathway. Even if you look at the other definitions that the defense side raises out of Macmillan and Cambridge dictionaries, those definitions talk about a causal connection. Whatever's leading to causes the result. In a criminal proceeding, ancillary proceedings are not in that pathway leading directly to a conviction. Those ancillary hearings, those motions in limine, those evidentiary hearings, what they do, it's the way the trial court sets the rules for how the proceeding leading to a conviction is going to be run. Anything else is outside the pathway. We can talk about the different examples that the defense raises, but they are factually distinguishable. Process of negotiation leading to a settlement. Of course, everything you do during your negotiation is part of your settlement. It's part of the pathway. It leads you directly there. In a criminal scheme, if it doesn't lead you there, it shouldn't be considered. Examples very quickly before my time is up. Let's look at a Stanaway hearing, which always involves an in-camera review of psychological or medical reports. What happens if a trial court excludes those reports, which nobody gets to look at? It's then reversed. We see now that there is information in those files containing exculpatory information. Under this Court of Appeals ruling, a defendant or a plaintiff can't rely on them in a WICA claim. That undermines the purpose of the statute. It goes strictly against the plain language of the statute itself. Pretrial hearings, they set the stage. They determine which evidence comes in. They don't tend towards or result in a conviction. Any questions?
Any questions for Ms. Frankel? I know we're trying to reserve some time.
I have a quick question, but I don't want it to eat into rebuttal if that's possible. Thank you, Ms. Frankel, for being here and for explaining your office's change of position. I think everyone appreciates the work that you've done to get to this point. I guess I'm just curious what your thoughts are now on what exactly our court should do. Should we answer the question on what qualifies as new evidence, or based on the state's concession, should we vacate the Court of Appeals judgment and remand it for determination on the issue that wasn't addressed by the Court of Appeals the first time?
Certainly, that's the simplest way to handle it. And I would say that's the easy answer, but the problem is the question will still remain.
Do you think that this is the right case to answer that question? Do you think we have enough with this case to be able to present a rule that is able to be followed based on the, this is kind of a complicated case. So I'm just, do you think that this is the right case? We have WICA cases, it seems like every month. So, it's very possible that there's one in the pipeline that may help us establish that rule better than this case. So I'm just curious on your thoughts.
I'm sorry, I'm not sure that there's an easy case. I think that the problem with these WICA claims is that they always give us a glitch. There's always a bump in the road, and we're always trying to apply what appears to be plain language. So I don't know that there's ever going to be an easy case.
Okay, thank you, and thank you for being here today. Appreciate it.
Thank you very much.
Any additional questions for Ms. Okay.
I have a question, Counsel. You were talking about the definition of leading to and as resulting in or tending towards. But really there's two, and I think that's probably the right definition, but really there's two interpretations that are being urged. One is whether it's the leading to plaintiff's conviction is a limitation to these criminal proceedings, right? To this case, whether that's a reasonable interpretation of that phrase, or whether the one you're now urging is the correct interpretation, where it's somehow we're to determine which of the proceedings in the case somehow put us on the more of an affirmative path, I guess, to the conviction. Let's assume for the moment that the court were, and I'm not saying we would or wouldn't, but say that we thought that the phrase was ambiguous, that it was, evenly divided or close between those two interpretations. Can you tell me any reason why you think the legislature might decide to exclude hearings that are significant enough where the defendant would have the right to be present and where evidence is presented at those hearings? Why the legislature would exclude those from the definition of new evidence, but include others?
No, I don't know why you would exclude evidence that is from consideration in a WICA complaint, if I understand you correctly.
Yeah, there's no rationale why the legislature would carve it up the way that you're suggesting it did. Is that fair?
I don't know that they, and perhaps I'm not understanding the way that Your Honor phrased the question. I think that they didn't carve it up. I think they specifically said the only evidence that is new evidence, no, that is not new evidence, is if it was introduced in a proceeding leading to a plaintiff's conviction. Those proceedings are proceedings which result in a conviction.
I understand. What can you posit any reason why the legislature would make the distinction that you're saying that you think now that they made? That they would carve out as an exception?
I don't know. I don't know why they would, Judge. I will only add that I don't know that the legislators that put the statute together were all lawyers thinking along the same lines that we are. We're trying to interpret it looking back. I don't know if the legislature would look at it and do it differently now. I know that this court in other cases has encouraged the legislature to take a second look at WICA and make sure that what the statute says is what it was intended to say. I don't have an answer to that question.
Thank you, counsel.
Any additional questions for Ms. Frankel? Thank you, counsel.
Thank you.
Yeah, we appreciate your being here. Mr. Van Gartlen, you may proceed.
Thank you, Chief Justice, Justices, and may it please the court. Assistant Solicitor General Linus Bang-Hartlin on behalf of the defendant, State of Michigan, and supporting the defendant's position that that this court should either deny leave to appeal or affirm the decision below, because the Court of Appeals correctly held that this was not new evidence because it was presented in the proceedings leading to the plaintiff's conviction. I think the point that I'm going to start with here is that there is some discussion in the briefing about sort of which definition, which approach to take that would effectuate kind of the purpose of the WICA. And I think that is not very helpful, except maybe to a very limited extent, which I can get to in a minute. I think that to say the purpose of the WICA is to compensate people who are wrongly incarcerated or wrongly imprisoned and the implication then that you should then sort of defer or default to allowing a claim. I don't think that that is correct any more than it would be for me to say that the purpose of the legislature in enacting the WICA is to put certain barriers in the way, which I think is also true. Lines were drawn in the statute, and certain lines were drawn that people might disagree with in both directions. So I think that anything that would either allow relief or bar relief might well be consistent with the purpose of the legislature. So I think that what we need to really focus on is the plain language that the legislature put in the statute, and just purely what is the meaning of the proceedings leading to the plaintiff's conviction. And again, to focus on the choices the legislature made. The legislature didn't say the proceeding singular that resulted in the plaintiff's conviction, the proceeding at which the plaintiff was convicted, right? These are proceedings plural that led to, and I agree with my colleagues, this is the path, this is the route, this is the process, and it begins with, a district court arraignment. It includes a preliminary examination. It includes a Walker hearing and all of these hearings, including the hearings that, as my colleague said, set the rules for the trial. Although this, I would point out, this isn't one of those. This isn't a 404B hearing or a Walker hearing that sets the rules. This is an entrapment hearing. If this plaintiff had prevailed, the defendant at the time had prevailed, right, he would have been, effectively acquitted, right? Not necessarily a factual finding of innocence, but this would have, this wasn't setting the rules. So I think it's a little more important than that. But again, this is the path, and if I, borrow sort of my brother counsel's analogy, right? Detroit is east of me. If I want to head to Detroit, I start out heading west because I have to go west to get to the highway that leads to the other highway that leads to Detroit. So the path isn't always in the direction of the destination, but if you call me when I'm driving west on that road, I say I'm on my way to Detroit. I'm on the road that leads me to Detroit. And it's the same thing. All of these hearings are part of the proceedings that lead to the conviction, because you had to have this entrapment hearing. He couldn't have been convicted without it. Having demanded the entrapment hearing, having made the prima facie case for entrapment, the court couldn't have convicted him without holding this hearing and holding that he wasn't, as a matter of law, entrapped. And if it had done so, if it had said, no, you're not getting a hearing, or I'm reserving judgment on the question, right, that would be reversed. That wouldn't be a legitimate conviction. This was part of the process.
Let me interrupt you just so you can make sure you have a chance to answer all the questions we have.
Oh yeah, absolutely.
I apologize for cutting you off.
Oh, not at all.
And we are going to start with Justice Clement.
No questions. Thank you.
Thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
No questions.
Thank you.
Justice Zara.
No questions. Thank you very much.
Thank you.
Justice Viviano.
No questions.
Is Justice Bernstein connected? I know there was an issue with his connection. You may continue to use your time. I may return to you if Justice Bernstein has any questions for you, counsel. We lost him for a second. We're trying to get him back. So.
Okay. Would you like me to stop the clock until he's back, or continue?
Thank you for holding.
Oh,
we'll stop the clock for a second and listen to this nice music, which you can enjoy, and we'll return momentarily. There's a great key change that comes in a couple of minutes. Let's see. Oh, you didn't get it. Justice Bernstein, you're back. Sorry about that. We lost you.
Yes, thank you. No problem. No problem at all.
And I don't know when we lost you, but we are hearing from the Attorney General's, the Attorney General in support of the Court of Appeals opinion. And do you want to proceed with any questions, or do you want to listen to some more argument and then we can come back to you?
No, I'm fine. I'll keep listening. Thank you so much, Chief.
Okay, Mr. Bangertland, you may continue. And I probably will circle back and see if Justice Bernstein has questions after the rest of your argument.
all right. Thank you. So I think the next point that I would come to then is that I mentioned that there is a way that I think the legislature's purpose may be evident in this language. And what occurred to me is that it was pointed out that the legislature said new evidence and didn't say newly discovered evidence. That was mentioned in one of the briefs, and that there's a difference between new evidence and newly discovered evidence. And I think there might have been a suggestion that our definition is somehow congruent with newly discovered evidence, and that's not correct, because we understand that new evidence has to be evidence that was not presented, right? Newly discovered evidence, it doesn't matter if it was presented or not. If the defendant had it, it's not newly discovered. And under some standards in some laws. It actually, even if the evidence could have been discovered, even if the defendant didn't have it but could have had it with reasonable diligence, right, then it's not newly discovered. And I think the reason, I think the legislature's choice of rejecting any newly discovered evidence standard, I think serves as some evidence that the legislature wanted this statute to be relatively easy to administer. Newly discovered evidence often requires tricky factual findings. You have to have evidentiary hearings about what the defendant knew and when the defendant knew it. You delve back in the record. You have to make credibility determinations where the defendant says, no, I didn't know. And then even more so in those cases where reasonable diligence, if you have to answer hypotheticals about, well, if this lawyer had called this person, if so-and-so had, would this, what is reasonable diligence? Legislature short-circuited the entire thing and said, new evidence, you look at the record, what was presented, right? And although that's kind of an adjacent question to the one we have here, it shows that the legislature wanted this to be relatively easy to administer. And I think that they didn't want to carve it up into, trial and plea takings, and we're not sure what other proceedings. Mr. Bunger said at least those two, but it might be other ones. Is a preliminary examination count? I think we pointed out in the brief that there's arguments both ways about preliminary examination. And there's case law that says a prelim isn't for establishing guilt or innocence. So, maybe under the plaintiff's view, that doesn't count. But at the same time, I think if you were to put 100 criminal lawyers and judges in a room and ask them, without the WICA context, just ask them straight out, is a preliminary examination a proceeding leading to a defendant's conviction? 100 would say yes. I think that's just the natural reading of the language. It's part of the path there. So whether a Walker hearing, a Stanaway hearing, an entrapment hearing is or not, I understand that there is good faith debate about it, but I don't think the legislature wanted to carve it up that way. I think they wanted to take the entire path leading there, the proceedings plural, leading to, not at which the conviction happens, but the entire path. And I think that that's what they wanted to do, in part because that's a much easier to administer statute.
So let me follow up on that question, Council. So what's your answer to Mr. Bindor's example of an alibi notice hearing, for example, that's inappropriately excluded, or I think what might be a similar example, if a prosecutor seeks a ruling from a judge about whether he has to turn over evidence that might be exculpatory, and the judge incorrectly determines that it's not, and later it becomes clear that it is, but there was this discovery proceeding that preceded the trial. Why should those claimants be excluded? Just that's the way the statute rolls. And
ultimately, that's the way the statute goes. I think the Stanaway question is probably the most difficult one, and I think there may be. I think that question may hinge on the meaning of presented in. I think that the stuff that is turned over to the judge at a Stanaway proceeding to be reviewed in camera, I'm not going to commit to a position here, but I think that may well not be presented in the proceedings, even though the Stanaway hearing is one of those proceedings. But as far as the alibi hearing, I think that is a line that the legislature drew. I think that, as I said at the outset, there are lines that they drew that may appear inequitable in both directions. I'm aware that other state legislatures have said, if you plead guilty, you don't get wrongful imprisonment compensation. Michigan made a different choice. People could argue about that, but that's the choice they made. And I would not stand up here and say, well, he swore under oath that he's guilty. He can't get. That's the choice. We accept it. And I think that it's the same thing. It may appear inequitable that this evidence that was, in this hypothetical that was presented, airtight alibi, is excluded, but again, that is the choice the legislature made, and we have to ask the court to honor it. I don't think that this is an example of something that appears inequitable. I think this is, I think that as far as to the extent this court considers the equities, I think that the guilty plea should be considered. But again, we're not arguing from the equities here. I think this is an argument about the plain statutory language.
Thank you. Let me just circle back to Justice Bernstein, who I had to skip before. Justice Bernstein.
Hey, counsel. Good morning. And I appreciate your argument, but I just feel compelled to ask just one question: is that as you read WICA, wasn't it really the goal of the legislature to ultimately allow for compensation for exonerees, which would follow in this case?
Well, first of all, I would not agree that Mr. Maples was exonerated. I think that his conviction was overturned, and there's a difference in my mind between exoneration, which is a finding of innocence, and the overturning of a conviction, which is based on a denial of a constitutional right. So I would like to set that. I think the other thing is that I don't think the legislature intended to broadly compensate exonerees. I think the legislature intended to compensate some exonerees under some circumstances when they can make some showings. And I think the legislature could have written a much shorter statute if it had intended to broadly compensate everyone who was wrongfully convicted. And it wouldn't have to put forth these requirements that are in the statute about new evidence and about defining what new evidence is. It could have said, the legislature could easily have said, if your conviction was overturned on appeal or on habeas, then you're entitled to money. And it didn't, right? It said you have to make these showings. And so, no, I think that both the entitlement to relief and the limitations on relief are both consistent and part of the legislature's plan and consistent with the purpose of the legislature of passing the WICA.
Counsel, thank you.
Thank you, Your Honor.
Are there additional, let me make sure if anybody else have additional questions for Mr. Bangertland? Okay, sorry, you may proceed if you have.
Thank you. I don't have much else. I just very briefly would address Justice Zara's question about whether this is the right case to do it, given the other issues. We addressed those in a footnote in the brief because of sort of the text of this court's ordering the MOA. But we would press the fact that this isn't the right case because although my brother counsel has said he's confident that they'll prevail on remand, I'm at least equally confident that they will not. Whether or not Mr. Maples is innocent, we could debate, but whether or not Mr. Maples his conviction was overturned because he's innocent, I think there's no debate. The Sixth Circuit opinion, it's not based on his innocence, it's based on the denial of effective assistance of counsel. So I think the way the court rules in this case, if it chooses to grant leave, and if it chooses to rule, will not affect whether Mr. Maples gets compensation. It'll just affect whether the decision below stands or falls. So I think this might not be the right case to do it. With that, unless there are any other questions, we request this court deny leave or affirm the decision below.
Thank you, counsel. Mr. Bindor, we ate up your time by asking Ms. Frankel more questions than she had time for. Let me just see if anybody has follow-up questions for you. Briefly, are there additional questions for Mr. Bindor from any member of the court? I don't see any. You may briefly respond with your 1 minute and 41 seconds.
Thank you, Your Honor. I think when counsel says that Mr. Maples' conviction was reversed, that's only part of the story. The case was later dismissed once the evidence became available, and that's, as part of the statute, dismissal is sufficient. I'd like to thank the Attorney General's office for its continued examination of the meaning of the statute. I think it's the high point of public service to be able to take a position that you think is right, regardless of whether it seems to be in your client's best interest. If I can address Justice Viviano's question, I think the line that the statute was trying to draw goes something like this. We're not compensating all reversals. We are taking care of those cases where the evidence that would have avoided the incarceration in the first place was not available then, but is available now. I think the DNA is certainly a fitting example, but I think the broader distinction is, was this evidence that the defendant could have used at the trial? If so, and if he got convicted for extraneous reasons, that doesn't call for compensation. But if the conviction was due to the unavailability of evidence at the time, which is available now, that's the distinction I think they're drawing. And I think that's why Mr. Maples falls on the side of being able to meet that prong. as to the causal nexus issue.
Why didn't the legislature say that, if that's what they were trying to do?
Well, I think that they did, albeit in awkward language. For
They don't use the
example,
word unavailability, do they?
well, they say new. Remember that this definition relates to the phrase new evidence. And when they use the phrase new evidence, and it's defined technically, but the first thing that comes to mind when you're talking about new evidence is evidence that's available now and wasn't available recently. And I think
that's a reasonable definition, but it's just not the one they picked.
well,
That's the problem, isn't it? They could have said that, but they didn't say that.
well, they did say new evidence. Now, I agree. They then went on to
They
come
defined
up
it.
with, they defined it in a way that I think we're all grappling with understanding right now. But I think that the core concept of new evidence, and when you look at things like DNA and other things, it makes sense to me that the legislature is trying to compensate that subgroup of exonerees who didn't have available the means of acquittal before, but do now. I think that's the core distinction, the core purpose. If you're looking for a reason why they allow some people to get compensation and others not to. And finally, as to that causal nexus question, I think the facts are as clear here as you will ever have. We've got the Sixth Circuit opinion, which explains why it was granted, in part because of prejudice to the defense from being unable to present the exonerating testimony. So I think this would be a good case to address that issue, either by supplemental briefing or by the Court of Appeals. But factually, I don't think it's particularly complicated. And with that,
Thank you, counsel. We appreciate all of your presentations. Very helpful. The case will be submitted, and we will now be on break. We'll return at 12:30 to hear 2 more cases.